bridging the gap. Last week's class and this week's class really are the bridges between connecting and controlling. And this is formally the first week of the controlling meme. And just as a review, you know that creating was the first part of the course, and that ended up thematically really being about mods. Connecting ended up thematically being about EULAs, and you may think this is all planned in advance, but all classes are different, all groups are different, and I don't really know what the theme for this class for controlling is going to be. Roughly, what we are going to talk about is originality, which Jennifer Kelly got off on last week, and Andy Moore is going to continue. I'll talk about that in a minute. This week, the next week we're going to talk about violence and social issues and sexism in games, and that's usually a intense class, and Dr. Kimberly Voll is going to be our guest commentator throughout that class. And then the week after, we're going to talk about a lot of things, but primarily we're going to talk about privacy and surveillance in a video game context. So it's a pretty intense and interesting 3 weeks in terms of subject matter. But having said that, it's impossible to know what will really emerge. So today, as you work through controlling creativity, think of it as a parallel to the first class. And we're going to come back to this, the first class of creating, which was if Picasso had painted a round object, which was what's the threshold for creativity that attracts intellectual property protection? Very, very low. But there was resistance to it. And we're today going to talk about originality. And originality is not a completely comfortable word with creativity. And the fascinating double standard that emerges is that once you've created something, and again, in a copyright context, that threshold is very low, all derivatives of it belong to you, and cracking the derivative code, if I can call it that, becomes quite high. So there's a contradiction. Once you've got the IP, you then, in theory, in copyright theory, have quite a lot. But you didn't have to get much to get it in the first place. So is that a paradox? Is that a problem? Is that okay? Always for you to decide, but we'll go through the issues. So the other part that's going to show up, that we've talked a lot about, that's going to show up today, is what is a video game? And that is, again, where we're going to end up. In many ways, we started thanks to many of you at the beginning of the course and started that debate and brought it to the website. And we're pretty well going to end that today. Not necessarily with definitive answers, but hopefully at least we'll feel thematically satisfied. Now, before I go there, in terms of follow-ups, today, the way we've structured today's class is a little bit different because you're used to first hour hearing from me and then guest speaker for the second hour. Originally, I thought this week and next week's classes from experience were so full that having a guest speaker wouldn't work because it wouldn't allow for questions. What I thought of, and I really think it'll work, but we are about to find out, is to invite guest commentators in who will come in for, if not all the class, most of the class, be able to interact, ask questions, challenge, and also probably make a shorter presentation than the full hour that our guests usually have, and make it kind of more fluid with 2 open mics. So this week we have Andy Moore, who is a colleague at the Center for Digital Media and a video game developer who has created original IP and has fought clones and has a fair bit of experience and a great interest in teaching. So he's going to share the proverbial stage throughout. So welcome, Andy.
Hello.
And he will do a short presentation, or a presentation, I'm not limiting it, in a little while. So I've created a break in my slides for that. So in terms of follow-ups, I'm not going to spend much time on it, but I'm still working on this, and I just wanted to note one small change. You've heard all about this. But I realized that I had put big data in the future. Big data is not in the future. It's here now. And what that will do in terms of justice is an interesting question. And where I've come to is that the definition of justice that big data will inspire is a defining of boundaries. And justice becomes boundary definition rather than one sort of equal standard. So what does boundary definition mean? Think about, those of you who've taken the courses related to this, think about sexual harassment in the workplace. Think about what the law does there. It defines harassment in terms of the person who's being harassed and what their experience is. To move maybe a little closer to our area, think about what the Supreme Court of Canada has done with fair use in the pentology. Said that fair use is determined by the user, not, what is fair will be determined by you as the user of the software, as the player of the game, more than some standard that the developer or the distributor sets across the board. So it's much more individualized, it's much more contextual. And it's much more about what are the appropriate boundaries. So I think that's maybe where we're going generally. And when you think of what big data does, maybe that makes sense. And then I've moved virtual reality, which was totally off the sheet, into the future sense of technology. And I have no idea what that will do to law. So if anybody has any ideas, let me know. So how is that relevant to what we're doing? Well, it's really relevant to last week. And it ties into very strongly this week. So last week, and I'm going to try and resolve some of these things, or at least deal with some of these things, not resolve them, in the first part of the class before we get to Andy's presentation. But last week, I hope I left you with a bit of a cliffhanger. I try and have at least one cliffhanger a week. And that is, okay, so yeah, I see what this new tech might look like. But what really are the legal answers to the questions posed? And I guess what my thinking around memes of technology and justice suggests is we can't know what the answers are, because it's the effect of communications evolution and the evolution of technology that will actually define, to some extent, the principles of justice and lots of other principles in the world that are emergent that get applied. So it's a bit circular, and we're not really in a position. That's why law is having overtly as much challenge as it has, because it's expected to have answers. But it can't really have answers until it's immersed in the context. So, you know, the way I've now put it is law and justice can never adequately resolve communications tech-based issues precisely because communications and tech memes proactively define the future meanings of justice and the forms law will take, or more bravely, concepts of law and justice do not shape communications technologies nearly as much as they are shaped by them. So, with that caveat, let's talk about future tech and try and parse out what will be the important legal principles that apply. So really just taking off from last week and continuing that talk. Going to take it through two levels, but not to the most complicated, not to telepathic gaming, which, by the way, was Andy's invention. I alluded last week to talking to some colleagues at the center about what the future would bring, and it was Andy and another mutual colleague of ours, and we concocted that scenario together. So
the Matrix, basically.
Yes, basically the Matrix. So I'm going to go through two levels, and the first is a really simple one. This is something that we did in my class at the Center for Digital Media. Asked the class, actually one of the guest speakers I brought in did a workshop with the class on what the future technology and digital media would be. And we have all our walls are whiteboards. So if you can imagine that, so on every wall, it literally is a whiteboard. You could write on every wall at the center. So they set it up. So he had a series of questions and a series of options, which you'll at least see the implications of in what I'm about to show you. And then they worked through as a class what they thought the future was going to look like in digital media under a series of rubrics. And then I just decided the following week to take those rubrics and feed back to them a very simplistic legal analysis. Remember, these are not law students. These are digital media graduate students. So the first issue was hardware, and the class decided that the future was in mobile and wearable. You can agree with that, you can disagree with that, but you know, not console-based, not screen-based, not laptop-based, but basically Google Glass as a mobile device. And in legal terms, that's a shrinking magic circle. We'll talk more about the magic circle today, but we have talked about it, which means more legal intervention. So the question of where does law implicate itself into the magic circle of gaming? Well, as we move out into the real world, pretty well everywhere. Second topic that the students went through is what's the business model? And they decided subscription and ads. That's pretty conventional. That's more or less what we have now. But they felt that was going to be the future. And in legal terms, that turns into big data privacy issues. And more particularly, you've heard about this paper before, digital market manipulation by Ryan Calo at University of Washington in Seattle. Distribution. They were really clear, and I think you're equally clear on this from some of the discussions we've had. It's a streaming model. It's a Netflix model. It's not cable TV. It's essentially the over-the-top model. Here, the legal issues are a bit inverse. Their resistance to change, which is epitomized in the regulatory model, the CRTC. CRTC governs broadcasting. Well, if this stuff isn't broadcasting, we have seen for quite some time a real resistance among the cable companies, arguing to the CRTC, arguing to others that Netflix should be regulated on sort of national cultural grounds, on not having a level playing field grounds. They're competing with us and they're doing nothing for the system, et cetera. This has been going on for years and years. If you want to see kind of my take, which has held up reasonably well over time, you'll find under materials on the website, I gave a talk, a keynote at the Law Society of Upper Canada Media and Communications Conference in 2011, kind of on the subject. And that's where the broadcasters and the cable companies were at their most vociferous in saying, block Netflix now. And it's the CRTC's job to do that. And they didn't, and you'll see if you look at the talk that I said that the CRTC shouldn't, which certainly disappointed a lot of my friends, who I had come up in the broadcasting system with. But that resistance piece is very interesting. I'll just note that 2 or 3 weeks ago, Netflix did its first cable deal. And it's ironic, given some of our discussions in the class, it was either in Sweden or Finland. So a cable company is actually distributing Netflix as a straight pass-through, and it's going to be very interesting to see if that, in fact, becomes the model going forward. So from a cable perspective, is it if you can't beat them, join them? And have we reached a tipping point?
So just
please.
Two things. First, it seems that going back to kind of the revenue side of things, that this is opening up another stream of revenue for service providers, and that they can license their content in a new manner. But I was curious why, when you were talking about this the first time, and your classmates had come up with the ideas of subscription and ads, they hadn't seen big data in itself as a revenue model and selling that information.
I think that's a really that's a really good question. And it's hard to know because, and I didn't go back to the class. I see them tomorrow. I can ask them this. To the extent that group that did that work for the half hour they did it, saw the revenue stream off of big data, which really is an which is really advertising related money, right? Because what you're doing, what Facebook and Google are selling out of big data is completely ad related. So maybe they did see it within the circle, and rather than kind of the more limited, I'm going to sell to Molson's and they're going to be on my website. Because you're right, that's not even the future, that's the present, and that's the present that's clearly being extended.
I could chime in on that
Please.
too. From a creator standpoint, I don't care about big data, and I don't want to deal with that as a business model, as a revenue stream. So I see that as a future add-on service that someone like Google or Facebook or some bigger corporation will utilize or leverage as a revenue stream. But myself as a creator and the MDM students are all creators. They're not looking to form the next Google or the next Facebook or the next giant big data, data stream service provider. So when you're thinking about the future in that context, it's not even an option. Like, you don't care. It's like, what's the best way for me to make video games? Easy. Open up a McDonald's franchise. I'll make more money. Well, that's not the point. That's not what I'm trying to do.
Any other questions? Okay, so then the fourth and final category in the exercise was, what's the experience going to be like? And the answer, this one's kind of hard to argue. I hate the way this scrunches the screen and destroys my lovely slide, which, I swear to you, really, over here. Integrated TV, online, mobile, interact, oh, how did I do that? Uh-oh. What did I press that? Anyways, we'll go there in a second. And what that raises, which we're going to be talking a lot more about, is screen merge issues, which we talked about last week. Oh, so this is a pointer. Anybody have any idea what I may have done? Oh, okay, good. So in these screen merge issues, I want to leave you, and I think you really want some sort of example, and rightly so. So I'm going to use the example of defamation. It's almost like pick a law and apply it, because there's so many different laws, and what I'm really trying to get across is that you have to look at every legal aspect and then say, in a screen merge context, how is this different? So rather than go through every law of the land and do that, I'm just going to go through the exercise so that you at least see my version, which you can apply if you're doing a paper in the area. So the classics, I just use the classic statements in defamation law. What is used in the textbooks? So there's nothing, this is not editorialized. I didn't pick Hodgson for any other reason than this is the customarily stated, from an academic perspective, law of the land. The plaintiff in a defamation suit must prove 3 elements, the third of which is that the words complained of in their natural and ordinary meaning are defamatory of the plaintiff. So I used to do a lot of defamation work. What could be unclear about that? I don't care about the context. How could that possibly be unclear? Well, now put it in a merged screen context where you've got multiple feeds coming from multiple places of all sorts of stuff. And it's all on one screen, and one part of that one screen contains what may be a defamatory statement. So what does natural and ordinary meaning translate into in that context? Because natural and ordinary meaning in all the cases in defamation law, show this, is contextual. So what are you going to do with the context? And now to make it a little more difficult, not that it needs to be more difficult, remember that in this merged screen world, my screen, my merged screen, and your merged screen aren't the same because we have infinite customizability. Just like you and I don't have the same apps, we may have the same version of the iPhone, but we certainly don't have all the same apps. We're not going to have all the same inputs because we've customized it. So now what does that do to the contextual? So what about if everything on the screen is way worse than this defamatory statement? Is it still a defamation? What if everything on the screen is sarcastic and funny and lampooning, and my assumption as a reader or reviewer is that this was just another one of those statements? And again, because of the infinite customizability that we're talking about, no two people are going to be able to have the same thing on the screen. So how do you track it? Well, I know how you track it. You go to the NSA. But short of subpoenaing the NSA every time there's a defamation suit to see what everyone in the world has seen, how do you track it? Matt?
There's a case this summer where I think it was an 18-year-old gamer who was playing League of Legends, and he made some comment about how he's some sick guy. So someone was kind of teasing him sarcastically, said, "Oh yeah, I'm a sick guy, I'm going to go to school and shoot it up."
Yeah, I remember this.
A third party actually saw it, and he was in Texas or something like that, and she was Canadian, and she read it out of context. And I'm not agreeing with the statement that he made. It was humorous or anything like that, but it was clearly in the context meant to be sarcastic. But she took it out of context, especially when she wasn't able to view the context of the game that spilled over into the conversation. So that kind of thing is already being seen as this inability to appreciate the context of the entire situation.
And sarcasm. And we see lots of out of context statements, not necessarily, you have a great one because it's in a gaming sense, but there have been others in Facebook and elsewhere, and the authorities have jumped in. Sometimes when you're Googling pressure cooker, you're just looking for a pressure cooker. So the world is increasingly complicated around these things. So applying what is seemingly a very simple legal rule to that new context becomes horribly difficult, in fact. So now when you go to the harder part, and this is a slide from last week where I did kind of the merged screen sports example wish list. How do you break that down? And I don't know if anybody, well, I imagine somebody may have read it, but here's kind of a quick analysis. On the virtual arena front, the issues are going to be privacy issues. So yeah, I get it. I want to know, and you want to know, what friends you have that are in the crowd, and where they are, and where they're sitting, and what they see. And that's great, and that's fun, except it implicates everybody else's privacy in the crowd. Hugely, massively, in fact. Now think about it. Just change tracks away from defamation, away from privacy. Let's just go back to our mainstay, copyright. And remember that moral rights exist in Canada. And your copyright material is merged on a screen, which happens to be run, which has a ton of extreme right-wing Republican rhetoric. And your game is a little widget on that page. Well, I know how much you. I know what you think of the right-wing Republicans. I hope it's okay that I say that. I think the same thing. And your game is on that page, and you've put it out there, and you kind of makes it a little sick to your stomach. You don't want it there. And in Canada, you actually have some rights to say, I don't want it there. And that's what moral rights are. But again, screen merge issues really really enable that Snow versus Eaton Center problem. That was Snow's issue with the Eaton Center. I didn't make this artistic work of geese so that you could put Santa Claus hats on it. Well, that becomes exponentially more complicated in a merged screen world.
But in the merged screen world, aren't there two different types of merged screens? We have merged screen hypotheticals where a service provider is setting up a whole bunch of different things, and we can look at it either through an aggregator or as a service-based idea. And then we have a merged screen system as an application or whatever else have you, where you're the one controlling what gets put together.
So, first of all, I think it's a very valid point, and I think you're right that this happens on two levels. But I actually believe, I don't want to use the word merge again, but I really believe that those two different things, in other words, a third-party intervener who enables your merging and you doing your merging and making all the choices, that's eventually actually going to be one thing. Because the middle people are going to want you inevitably to have as much choice as possible. So I think you're right. If there is a middle person, certain kinds of offensive content may not even be available to you. But the reality is that even to this day, the ISPs, maybe they're tracking you, but you can still get onto the darknet if you want to. So, and in fact, the law, in terms of communications in Canada, I'm going to be a little careful because I don't totally know the American rules, but I think they're similar. But the telecommunications laws in Canada are very clear that the carrier cannot intervene in the content. So I do think that the choices will inevitably be yours. Now, you can delegate it back. You can say, no, I prefer you to put my playlist together. But it'll be you deciding that.
I don't think it's just choice of two either. I mean, as much as you want to put it under the microscope, you'll find more and more layers of merged screens, I guess. Like there's a game called World, WHIRLD. It's a Flash game. You can play on Flash Portals, which is an aggregator. Within this Flash game, you can play user-submitted Flash games. So, and each person can have their own playlist within the game, which is within another bigger playlist and bigger. And then the game submitted could be anything from the public, which could then in turn have more user-curated content. So, I mean, it's like turtles all the way down, right?
Yeah, it's like looking into one of those endless televisions showing the endless television. So yeah, that is likely where it's going to go. And then kind of one more thought is around trademark confusion. And I talked a little bit about that last week. If you're a big sponsor of the hockey team or the soccer team, you're going to inevitably see, however it arrives, you're going to see your competitors on the same screen that you're on. What I started thinking about, just to gloss on that, was, okay, can we control that through EULAs, or can we control that through contracts? And, I've kind of worked in the area, and I think it's really difficult. You're going to end up inevitably with a distributed network architecture, and the feeds are going to come from everywhere. So no one sponsor, no one corporation is going to be able to fully control, I hope, what's on your screen. And, you know, I can pretty well guarantee that if you're, you know, if they can, we're probably all moving to Linux anyways. So, and all of this is an old theme, all of this is made more difficult and more challenging, and I'll say this for like the 200th time, as real-world gaming emerges and as we step from the immersive digital screen into the even more immersive world where we're projecting the digital onto it. So as we bring the game into reality, this complicates things and also shrinks the magic circle. And you know, this is just sort of my favorite example. Ingress plus your own drone, and it starts getting very complicated. But it's very possible. And that's even before we get to the other stuff. So a couple of things that I just want to briefly mention. We've talked about a lot of this in terms of copyright and Magic Circle, but really want to talk about jurisdiction issues. Just at least mention to you that as we move into the real world, this gets very complicated. And this is in many ways traditional net law. Oh, there's a typo there, which I will fix. But there are different theories of jurisdiction. So what court will take jurisdiction over your actions on the worldwide net, even though they originate in Vancouver, British Columbia, is unknown to you, because it's not about origination. It tends to be moving towards where is the effect of what you do felt, and courts are increasingly, and remember this is, there's no one system. We don't have an international treaty around this. Courts are increasingly willing to take jurisdiction where the impact of your actions are felt, not where they originate from. So again, as we move into the real world, and we're multiplayer gaming, and it gets pretty complicated. So all of which leads us.
Hi, I'm Andy. I was born in Quebec City, and I am terrified of lawyers. I've never spoken to any law, anything ever before. And one of the reasons I'm kind of scared of lawyers is because I don't even know if I'm allowed to make that kind of joke. And just to demonstrate the point, when I came in and I set down my laptop, John looked at my screen and said, "Oh, I don't know if you should put that." It's like, really? Come on. Law. Anyway, I'm Andy. I'm Radial Games, pretty much. I'm an independent video game developer based out of here in Vancouver. Twitter, website, things like that. I have no idea what you really want to hear about from me, and I really wanted to see last week's talk, but the video editing didn't get done yet, so I couldn't quite see it. So what I have here is basically a slide deck that I normally present to other game developers about game law and cloning and IP issues from a more human standpoint, as opposed to the robotic evil overlords that are the lawyers. Maybe you guys one day. But I think the more human kind of how I deal with law and IP and all that kind of stuff, it's my opinion, and it's the way I do things, and it's the way that is probably on legal shaky ground. But I'm hoping, in the context of the future and where everything is going in terms of IP law in video games, maybe what I have to say now, which is legally stupid, may in the future, in fact, become law thanks to people like you. You know, the future of the industry, I guess. So this slide deck is very much intended for other developers, and I know, are any of you developers?
Yeah.
Yeah?
Couple of
No one weighs in? No, okay.
ones.
Maybe someone out there in video land. So I realize this content won't be specifically targeted at you, so I'm going to skip over some things or anything, but it's fully intended to be interactive. So like stop me at any point, and I will go into all sorts of details. So normally I talk about clones, and I need to distinguish clones from misfortune, because when we're talking about clones in the industry, there's a very kind of strict legal definition of what that is, but I don't give a shit about strict legal definitions, right? It's about feeling, and it's about how that impacts your work and your future in the industry. Here's an example of misfortune. This is a fantastic contraption, the first game that I worked on. It's developed by Colin Northway, who's like my best friend from high school, so inside job there. Versus the one on the top there is called Incredibots. You can see they look very visually distinct, or similar, not distinct, very visually similar. They even have similar goals, almost like everything between these two games is similar, but they were developed entirely in parallel without the developers knowing about each other's games. Both the games are developed completely in secret. There's no betas, there's no screenshots, there's no press releases, and they both launched on the same week. Now, this kind of thing comes up all the time, right? And it's really easy in this like world of litigation for one of these two to sue each other. And in fact, Incredibots tried suing Fantastic Contraption over this, which is terrible, right? But thankfully, there's a ton of documentation that never went anywhere. But still, like these are kind of some of the issues that we deal with when sometimes there's just a misfortunate situation. You can have things come up like this. So what does that make a clone then? Like that's just misfortune, right? That's not clone. No one cloned someone else. So what is a clone? Well, a clone is not necessarily a one-to-one duplication, which definitely happens. You can get really blatant things like Overgrowth is a game available, PC download right now. Someone took the source code, compiled their own version of the game, and sold it in the iOS App Store without permission from the owner. I mean, that's obviously infringement of some kind, right? I don't even know. Is infringement the right word?
Yeah.
Yeah, there you go. The Blocks Cometh, exact same thing. You can buy the Blocks Cometh on iOS, and it is not by the developers of the Blocks Cometh. They do not see a dime of that. Obviously bad. Magnificent Gizmos and Gadgets. Now this one, they took the exact same mechanics, and they changed the look and feel, I hate that phrase, to make it legally distinct. Now, that almost went to court as well, but did not go through because it wasn't worth the fight for a smallish kind of game, right? So these are things that are basically almost one-to-one clones, right? So the last example, though, had different levels, right? It had different gameplay bits to it. So I have a definition between clone and legally distinct. I think, in my terms, a clone is a game that maliciously duplicates another title. Maliciously is a very important keyword there. And I know normally if you have Microsoft v. Sony, you're not going to find anyone on either company that is acting and documenting their maliciousness, right? But in the smaller world, a guy like me who makes a blog post almost every day about what I'm feeling, oh, hell yeah, all that's documented. If I'm being malicious, it's really easy to figure it out. Just watch my Twitter stream. I'm malicious every day, right? So being malicious is something that is very relevant in the smaller scale when you're talking about indie games and smaller games.
Can I?
Yeah.
You know, I apologize. Being the lawyer, I'm going to put it in slightly legal terms.
Sure.
How do you feel about intentional as opposed to malicious? Because malicious is a very high standard, but intention is actually a pretty usable standard if it can be proven.
Yeah, so intent. Yeah, but intent to do what?
Right.
So, for example, I say here, bonus points if it beats it to market, right?
Yeah.
If I have my game, so this actually happened. I have a game, it's probably the next slide, but I don't know. I have a game called Steambirds, and
Yes.
I released it as a browser game, and I was developing an iOS version of the game. Someone made a completely new IP that replicated almost identically, but legally distinct, all of my core mechanics, and beat me to market. Now, they didn't beat me to market by mistake, right? They were intending to bring a new gameplay experience to a new market, and they knew that I was about to do the same, so they made a concerted effort to beat me there.
Okay, so they intended, but they
intended
may
to
not
beat
have
me to
been
market.
malicious because they were doing it in what they thought of as a normal business setting.
But I think that is malicious, because
Okay.
normal business is malicious.
Okay.
They could have waited 2 years and launched afterwards, but they're trying to capitalize on the situation.
So my point is that the use of the word malicious in the eyes of a judge
Yeah.
would be a very high standard.
Lowercase m malicious.
Yeah. Okay. Lowercase.
Andy
word.
says malicious,
Right.
not lawyer says malicious.
Got it.
Legally distinct is what you call your clone once lawyers get involved. I think that's what it is. So really, when it comes down to how to tell if your game is a clone, I prepared a nice list here. If you need a list to help you decide if your game is a clone or not, then it's probably a clone, right? Because if you're at that level of, walking the line, then you're probably crossing the line in someone's eyes. You're probably going to piss someone off. And legally speaking, well, who cares? You piss someone off, but you make money, yeah, right? But there are some bigger impacts, especially in the smaller indie game world. The guy that launched an iOS copy of my game Steambirds, he now works at McDonald's. His game was pulled from the App Store due to pressure from the development community, my friends, not because of any judge or lawyer. He tried to get a job in the game industry and failed because his name is now plastered all over the web as the person that did this. And he seriously does work in McDonald's in Italy. He's a manager, but still is not making games. When you cross these kinds of lines, you may be in the legal right, but you may be committing career suicide. Now, again, that's not an issue for Microsoft v. Sony. That is an issue for dudes standing here making QC jokes, right? So these are things that you have to think about even before lawyers get involved or, before you start going down the road of litigation and things like that. You have to start thinking about, as a content creator, how is this going to affect me and my career, regardless of any legal implications? Because you can be completely legally in the right, but be so a fraction of a degree off course morally, and it'll sink all of your chances in the industry. And, the game industry is huge, but it's incredibly insular. Incredibly. I know people at pretty much every major studio in the world, and I consider myself a nobody, right? I'm just some little indie developer, whatever. But I know everyone, and I get a lot of requests on
Referrals, personality.
Yeah, exactly, things like that, right?
Do we hire this guy or woman or et cetera, et cetera?
Yeah. So my first big hit was Steambirds, and I already mentioned I launched it. 16 days later, the iOS clone came out on the App Store. 16 days. So I think that 16 days is a big important point, and I'll loop back around to that a bit later, but it can happen incredibly quickly. It's really easy to duplicate content. And that wasn't the end of it. There's the iOS version. There's a second clone made by another company that largely duplicated everything. They took the propellers out, put in jet engines, so it was jet planes, but otherwise identical, even the level design identical. And they added multiplayer, which is another thing I was working on at the time. They beat me to market by about 3 months. So that was the second clone. The third clone was Bungie.
Wow.
Bungie. It's actually Bungie's publishing arm. They published a game called Crimson Steam Pirates,
I remember that.
which is identical to this game, except has boats instead of airplanes. But otherwise, identical. The boats even move the same as airplanes do. Right? But don't worry, the look and feel was totally different. It's totally, completely, legally okay. So I have a lot of experience with that. But here's a list of other clones that happened. I know you guys talked about last week, say Triple Town and I think Tiny Tower as well. But all the people on this list, all the games on this list, on the left side of this list, are my friends. They're the people that I have beers with at least twice a year, usually 4 or 5 times a year, and they live around the globe. Ones on the right side are the clones that came out that were, in most cases, very, very, very similar, but probably legally okay.
And you don't have beers. And you don't have beers.
I have never met a single one of them. Not even met, right? It's not like I was actively avoiding them. Those people aren't the types that go to the industry events, and they're the ones trying to make it in the world, but they don't quite do it quite right. Anyway, so some common arguments against clones. One of them is, well, everything's a clone. Content production is, you know, everyone's duplicating everyone else. A copy is a copy of a copy. Like, everything's copies. And that's true to a point, but everything's not a clone in the way that I define a clone. I mean, sure, Steambirds was based on, like, I came up with the game idea, I did the level design, I did everything else, but it was founded on a board game I played like 20 years ago, and I built the game based on a memory of that board game. So is Steambirds now a clone? Well, I'd argue no, because first of all, 20 years later, I wasn't beating anyone to market, right? If anyone else wanted to do something, anyway, but it's still completely different. Everything is not a clone. Everything is inspired by everything else, but not a clone. Another argument is the line is so fuzzy between what is clone and what is not a clone. So no, whatever. Don't worry about it. Well, just because the line's fuzzy doesn't mean the line doesn't exist. I can't tell you exactly where the line is. I can't tell you exactly what is a clone, what is not a clone, what is good, what is bad, legally or morally. You guys can probably tell legally. But morally is a really hard one. And just because it's hard to tell doesn't mean I can't point at one and say yes or no to that specific scenario.
So, to try and address your question a little bit, you know, I as you've heard, I don't think that the law has caught up with the technology, and I think that's actually just it's a tautological problem. I don't know that we can solve it. Where the law has caught up is we know what a copy is.
Right.
And what we're trying to build, I think, if we parse through where law is progressing, is we're building bridges from copy to clone. And we are going to get to an understanding of clone. On the flip side of that, we get to user mod rights. And then how does that fit in? And we are 5 years away, I think, from really getting that to a place of real clarity. We see the issue, but we're not there.
Not quite there yet, yeah. That almost brings me to the next slide, actually. Another common argument against cloning is that game design has no inherent value on its own. And fuck you if you think so. I mean, legally, yes, it's true. Legally, my job, my passion, my core has no legal standing, no legal protection whatsoever. And that drives me bananas. Damn it. And this is actual things that, like, this has actually happened to me, right? People just change the art in my game, and they get away scot-free. What the fuck? How can that be right, right? The fact that, I'll loop back now to the 16 days thing. I spent almost a year developing the core mechanics of Steambirds. It took 16 days to replicate, right? Because coming up with the idea, it's not, oh, it's just an idea. It's a year of work. A whole year of, like, my heart and soul poured into it, of the things that I tried and failed, picking out the best ones. It's like farming, you know, you replant all the best vegetables and then you watch them grow and then you replant the best of those, right? There's this huge cycle that anyone can shortcut by just looking at your end product. And saying that that work has no value unless I slap an art asset on it, that's bullshit. You guys have to fix that. You better fix that.
It's really interesting. You've completely undermined the rest of my talk. I may as well go home now.
But I mean, like, this is my personal, because there's, like, game design is really, really hard to define. It's really, really difficult. I could say, I spent a year of my heart and soul on that, but I didn't. I spent 2 months, right? Well, am I lying now? Was it actually an afternoon, right? There's no way to really measure. I mean, sure, you can look up records and logs and whatever, but I mean, people say like some games are like 12 years in development, but you know, they completely threw out everything 6 months ago and started from scratch. Well, is it really 12 years in development? Is it really 12 years of effort? It's kind of like the chocolate shop that was established 1898, but the building wasn't even erected until like 1940. So what's, you know, like there's all these weird questions that come around with that. Anyway, I'm not saying you're legally in the wrong if you think game design has no value. In fact, you're probably in the right. You're just a jerk for thinking so. So legally correct does not equal morally correct. And I think that phrase looks really good on the leather backdrop that I put there. It looks very legally. But you can choose how to react to the scenario. The way I react is I say things like, Bungie is being a moral dick. Bungie is being a jerk to me. And they're completely legally in the right, and good luck, sir. They're jerks, right? That's what I say. But there's other people, like Notch from Minecraft. He just said, oh yeah, congrats guys from Fortress Craft. Awesome, good job. And he doesn't care. He doesn't care about any of this. And he's got a very positive, forward attitude towards it. So attitudes can definitely make or break a studio. And if any of you go on to have a practice or whatever, I don't know what your aspirations are, and you're representing an indie game studio, you have to keep in mind that a legal decision may be entirely in the right, but may completely undermine the future of that studio. And how you phrase things is very, very important, because me saying things like this costs me a lot of opportunities. But I think it is artistically important for me to say so anyway, so I'm shooting myself in the foot by half the things I've said today. But I don't care, because I want there to be a better tomorrow. Yeah. That's all I have.
That's awesome. Thank you.
Yeah, totally open for questions and everything else. I hope that was relevant.
That was totally relevant. And while I put this on, why don't you ask some questions? The mic is live, so go for it. You.
Go ahead, Nick. I'm just curious to hear about in the situations where some other developers own your game. At what point in the whole process have they gotten their hands on your stuff?
It's usually after I launch a game.
Okay.
So, I mean, I launch it, it's out there, right? But the way I develop games is I develop a bunch of prototypes, and I put them all out there, and then I see which one's doing the best, and then I iterate on it. So normally where someone would have a 2 or 3 year game dev cycle, usually I put out a game a month, and then I pick from the best and polish that up. Now, I make the game a month, I see one's being popular, I'm like, oh snap, I gotta work on that, right? And then I work on the iOS version, I work on the sequel, I work on the multiplayer version, and before I can get those out the door, I take a look at the market. Now there's 5 copies of the game out there in various states of legalities. Legal.
So I have a question.
Yeah.
How do you look at modding? How do you feel about modding as a right, as a user's right, as a developer's right?
Well, I think it depends on the developer, because some games you can mod. It's built into the game.
Yeah.
And it's obvious that the creators are okay with modding that game. Other games don't have modding capability because the developer didn't have time to implement it or money to implement it, but they wanted it, right? So their intent matters there. But if my game is a flock of geese on Eaton Center, and the mod is putting Santa hats on them, I can understand them taking offense to that, because I mean that's you have to consider the artistic intent behind it. Some games, like the Stanley Parable, was originally a Half-Life 2 mod, and they ran into their own issues with that, because you can't really monetize mods easily. So it's fine if you want to make a fan creation, but as soon as you want to make $1 with it, it's like, whoa, hold on. You can't make $1 with this mod. most games that have modding capabilities, there's no way to purchase or pay for those mods. Most. There are some. But, I mean, that's kind of like where it's changing. So what Stanley Parable did is they just rewrote the game using largely the same tools, but now it's no longer a mod. Now they're able to monetize it better.
Yeah. And we've seen that before, and that goes to legal versus.
Yeah.
But modding as a fan-based or user-based creation, you have no problem with.
No, I mean, for a large part, modding is just a celebration of enjoying the content. I mean, I drew Mario in my notebook when I was in elementary school, right? So, I mean, is that illegal? Was I infringing on IP? Probably.
Yeah, I mean, ironically, it is, which is part of the problem.
Yeah.
On the other hand, you meet yourself on the other side
Mm-hmm.
because somebody created Mario. There was someone like you who drew Mario.
So, as a creator, what upsets me is when someone creates something and they say, hey, look, I loved your game so much. Actually, the way I found out about the iOS game was the developer reached out to me, the Steambird's version of iOS. He reached out to me and said, hey, I'm such a fan. I started selling a version of your game in the store for 99 cents. Like, isn't that amazing? Wow. I'm like, wow, it's so nice to have fans like this. Yeah. Wait, no. I mean, if they put it out there for free, maybe, but I mean, they're undermining my market potential, and it's not like it's my market potential, and I might one day start thinking about going to iOS. It's like I was launching 2 weeks from then. Like I already had a game lined up, ready to go, and they're just undermining it. So that's why timing is important, right? Copying a game 20 years later when there's been obvious no movement on the IP, maybe, and maybe 20 years is a magic number that I use, and the industry uses 80 years or 100, whatever it is now.
Well, the U.S. industry uses 70.
Yeah.
Canada uses 50. In a digital world, it probably needs to revert back to the original statute, which was 8.
Yeah,
But
eight sounds good to me. 8 sounds like a nice number.
okay. Well, thank you. And it definitely informs. I asked Andy what he liked, and licorice is what he likes. So
Oh, like
that was.
I thought
that
they were
was
electrical cables. I was confused.
Now that's some of your competitors. So, so back to where we were in terms of bridging, creating, and controlling through connecting. And so why is this important? So here's what really happens. Every time there are tech breakthroughs. So what does last week's class have to do with this week's class? Last week was about future tech. This week is about control mechanisms and the beginning of control mechanisms on gaming. Well, every time there's future tech, at the beginning of that cycle is where you're likeliest to get state, legal, regulatory intervention because there's something new. And as soon as there's something new, there are threats and issues. And, you know, I just give you there, this article is fabulous and well worth reading. 15 technologies the legacy content companies have sued in the past 15 years. It's kind of a nice symmetrical article. And the suits obviously involve some of these companies in terms of evolving technologies. But go back further and successful attempts and laws and regulation to regulate printing press and radio and television and cable and telephony. And so every time there is a breakthrough. Now what's really interesting, and this would require a sociologist and political scientist and maybe an anthropologist all working together with a little bit of legal help. But the evolution of the internet did not immediately attract state scrutinized regulation. State scrutiny and state regulation at its inception. Now, it's true the internet evolved from a military source and then through educational sources, and that and was kind of peripheral. But it sort of took everybody by surprise, and part of, and in no way is this a rationalization for what we're seeing the NSA or others doing, but part of this feels like catch-up to me. We didn't catch it at the front end and create the filters and controls and regulate who could be on and who can't be on. So we better figure out what's going on. And so it's interesting because I do feel like digital evaded the traditional new media approach. And these lawsuits that are referred to in this article are all private company versus private company. They're not state intervention. So yes, there are things that are slowing progress down, but they are between private parties rather than a regulator stepping in right up front and saying, okay, there's this wonderful new thing called the printing press, and we better catch it. And so only certain people can have licensed printing. I have an idea. Well, licensed printing presses, and only people that we, the state, know and trust will be able to decide what books are published and what manuscripts are published and what isn't. So that'll be our mechanism. Well, that obviously didn't happen in the digital world. I think it's a pretty profound question as to why that is.
I could jump in on that a little
Please
bit.
do.
There's, I think it's really interesting how slowly bureaucracy, government, and laws change, and how quickly technology changes. And I think a lot of the regulatory arguments about the internet end up in this state of let's wait and see. Like, we don't want to regulate Napster because next year it probably won't even exist. Like, if you want to regulate like PayPal, like 2 years from now, everything might be Bitcoins. Like, who knows? Who knows what the future is, right? So there's always this wait and see attitude because we can't respond fast enough to technology's change.
And I'm going to add one more thing. Sorry, I said it's going to take sociologists and anthropologists, but we've decided we are they. Yeah. I think the other thing that's profound in terms of the political stasis around this is possibly that interactivity has entered into the fray. So when you politically intervene, it's not to a group of, I mean, let's imagine when the printing press came out, you know, the group of 1,000 people in your country who want to write and publish something, or 5,000. It's now everybody who is a user. And that's a profoundly different political problem. And so I think it adds, I think your answer is spot on, but I think that adds to the answer. So they didn't react fast enough, and now the genie's out of the bottle, and if you start regulating the internet, you're actually regulating the entire political base.
And not just in Canada.
No,
you're regulating the entire, like, everything in the world, and there's no real mechanism for controlling global law like that.
So, but it is different. It's really interesting, and I haven't yet seen that parsed out in a purely academic setting yet. So
I have to go.
Yeah, Andy's gonna
I have to catch a bus.
leave us. Thank you so much. That was awesome. So obviously, where this ends up is that control issues and what I'll call going forward constraints on creativity are really the same thing. So that's the bridge between part one of the course and the part we're going into right now. Control are constraints on creativity. So I promised you the hard part. And I'm not sure that it's completely going to be satisfying to you. But I did try and think about it and couldn't get much beyond the obvious. So the telepathic gaming thing. You remember this? Basically, neurogaming in the real world. What are the legal issues? Pretty obvious to me. It really ends up being privacy. But there's there's an important point from my perspective that maybe has been alluded to, but needs to be articulated clearly. You can't open a one-way pipe that I know of. If you're creating a pipe that you are using to send your message to the world, there is a way back where others in the world can send you their message. And I know it may be technically possible to filter some of this out, but that really becomes the issue. And we're increasingly seeing it. I'm not picking on the NSA, although they deserve it, but we're increasingly seeing that though we look outwards, people can look in to us and reach us. And Ryan Calo's article, which I keep commending until everybody in this class reads it, really is about that. And it's about how by opening the outward bound channel, we're opening the inward bound channel, and potentially we don't have a chance because we can be manipulated through that open channel unless there's clear consumer protection / privacy regulations and laws enacted. So then the other part, we're going to go into it, is can the magic circle survive? So the magic circle, just remind everybody, is that special privileged place where we're just playing a game and the real world doesn't intervene. And real world laws have no place because this isn't the real world. This is its own separate universe, its own separate country. Don't tell me that the real world has to play any part of the rules or regulations or mechanisms when I'm multiplayer on, I'll use my game, Grand Prix Legends. It's not real. Leave it out. Well, as soon as you're multiplayer, we'll go into that. So what is the magic circle? Properly organized. The arena, the card table, the magic circle, the temple, the stage, the screen, the tennis court, the court of justice are all in form and function playgrounds, i.e. forbidden spots, isolated, hedged round, hallowed, within which special rules obtain. All are temporary worlds, hopefully not the court of justice, within the ordinary world dedicated to the performance of an act apart. So that theory was formulated by Johann Huizinga, who was obviously pre-digital, and this was about games per se and gameplay, not video games, and it was applied to the video game world in 2003 from an academic perspective. And I just want to track you through kind of the literature. I'll do this quickly on the Magic Circle. Friend of this course, Greg Listoka, in a paper with Dan Hunter in 2003, said about the online digital game world, in time perhaps they won't care what we think or what our laws say. They will live and love and law for themselves. Separate worlds. The Magic Circle applies. And this is very consciously a timeline that I'm trying to show you here. That was 2003. A lot of optimism. Separate world, our game world is our own. We'll have our own rules, we'll have our own mores, we'll have our own values, but they won't be the same as pertains to the, quote, real world. Jack Balkin, and we're not, I mean, you know Greg, Jack Balkin is no lightweight, Yale professor of constitutional law, chair of constitutional law, and chair, I think, of Yale ISP. 2004, still somewhat optimistic. In the future, virtual worlds are likely to become important spaces for innovation and free expression. Properly drafted iteration statutes can help promote these values. So now, yeah, the real world will obtain, but what should happen is that legislators should intervene and make sure that that space in the game world has elbow room. Let's make sure that we protect it. So yes, the real world applies, but let's use real world laws to make this a sacred and special place. Interesting position. Some movement. Edward Castronova, who is an economist, not a lawyer. You're starting to see the pessimism creep in a little bit, but we're still fighting for real world law not to apply. A legal framework for make-believe places will not be very fun to create either. But it will allow everyone, all of us, to spend time in worlds where magic is real. So it's not fun in real-world laws, and it's not going to be that much fun to figure out the framework for the digital world, but they are different. And we're going to have to engage in this somewhat challenging and painful exercise. So now we've moved to 2005, and you sort of see what's happening. Joshua Fairfield, virtual property, basically saying cyberspace is a real place. So he kind of moves to a different modality. Instead of wrestling with how much law should apply, and saying this is special, let's protect the boundary. It's a bit of a Houdini-esque move. This is just a different universe. I actually heard, I don't know that it was Joshua I heard, but I actually heard this at a conference in 2005, sort of a version of cyberspace needs its own flag. It's its own country. It will have all the rules, but it's an alternate place, and it can have a seat in the UN, for example, and it can have a flag, and you can be a citizen of cyberspace, or maybe you already are, or maybe it allows for dual citizenship. But this wasn't fanciful. This was real talk. And so he said, I propose a different answer. Cyberspace is neither a bad analogy nor a metaphor. Cyberspace is a descriptive term. By 2006, we're starting to see kind of neo-realism. James Grimmelman, who's an amazing legal academic, in the end talking about the real money trade. So now we're creating economies in games and in the virtual world. By 2006, we see where this is going. In the end, talking about the real money trade points out the deep interdependence of the virtual and the real. We're not going to be able to escape real world law because this is not a separate country. This is the real world. And now we come back to Joshua Fairfield 3 years later. Players in virtual worlds should understand that their behavior online is not entirely free from real-world scrutiny. This is a bit saddening. It was wonderful to live in the cyber Wild West, but every new frontier has its civilizing moments. So now the crucible is getting crossed. Yes, these are one world, and the one world is the real world. And then we get to Mia Consalvo, who is at Concordia University in Montreal and is the Canada Chair in Gaming Research, and a very nice person, and she kind of buries it. There is no innocent gaming. Players also have real lives with real commitments, expectations, hopes, and desires. That is also brought into the game world. Here, Azeroth, so she's doing World of Warcraft research. We can neither ignore such realities nor retreat to structuralist definitions of what makes or defines a game. Games are created through the act of gameplay, which is contingent on acts by players. And the article, fittingly enough, is called "There is no Magic Circle." And Ben Duransky, a year before, from a legal perspective, this is American Bar Association publication, an activity that occurs in a virtual environment is subject to real-world law if the user undertaking the activity reasonably understood or should have reasonably understood at the time of acting that the act would have real-world implications. So it's all real, but if you're doing harm and you understand that you're in the real world, I mean, the kind of the fascinating question is, well, what if you don't understand? But what if it wasn't reasonable for you to not understand? So if you accept that the magic circle is either very small or non-existent, Jedi mind trick, how do you look at what's original in video games? I know the two don't overtly seem related. But I think as the magic circle shrinks, so does, and Andy may disagree with me, and he's not here, sadly, to disagree with me. So does what's in a game. And I defend it on the same grounds. Step one, you know, is Bruce Boyden, games and other uncopyrightable systems. So the fact that there's a gamer involved means that the system itself is not copyrightable, in Boyden's words. And this is really parsed in many ways from Jennifer Kelly's presentation last week. The other steps of what is not a game not ideas or general concepts, not genres, not mandatory scenes that are de rigueur in a game of that sort, whatever the game is. We were talking about sort of horror zombie games and the necessity of having helicopters leaving malls in those sorts of games and in that sort of scenario. And as someone who doesn't know that genre, I got to say, wow, that seems so specific to me. Helicopter leaving a mall is a de rigueur part of a genre of game. We're like, really? Okay. We know that rules and play methods and common moves are not protectable, and we know stock characters are not protectable. So I do wish Andy was here to talk about this, but legally, that certainly leaves us with art. And even Atari versus Oman, the Register of Copyright would have said, it's got to be really, really good art. It can't be just any art. We know an underlying code, but that really means the code and the base code. And we know that sound is protectable. And we know that there's protection against plagiarism. So I suspect that to put Andy's talk in its proper perspective, the real thing we end up discussing is the extent to which cloning is plagiarism. But look and feel is how the court ends up making those decisions. So nothing here is really new, but when you're considering what is original, do think about flexibility in the Sony versus universal time shifting scenario. Think about the Supreme Court of Canada's articulation around fair dealing and user rights and the pentology. Think about, and I think this gets closest to Andy's point, thank God I can tell him we have moral rights in Canada, because really his argument is around attribution and especially integrity. If I listened to him and understood him properly. And knowing Andy, integrity would be a key word. We think that so much of what we do is original, and we may be deceiving ourselves about that. What I thought was really interesting about Andy's talk is he didn't put it in terms of originality. He put it in terms of hard work. I spent a year or 2 months or whatever sweating over this. That makes a lot of sense to me. So the effort part of the equation is important. And I may not account for it enough in some of the things I talked to you about. Point 5 is kind of in our view of kind of what's original and we are creators. There's kind of a neo-colonialism in it because we as North America are certainly net exporters of entertainment products, so it's very convenient in some ways to say, well, this is ours, and lots of other cultures don't abide by the same view of ownership. Sorry for the fine print. You'll have to download this online, but I wanted you to have a long list of cases that's relatively up to date, includes the 2 EA cases. And what this really is, you can find the cases online very easily, but I wanted you to see the articles that created context for them. And you've heard about you've heard about actually all of them. Some of them are fun. The Tolkien estate on Lord of the Rings online slot machines. It's, feels very Snow versus Eaton Century. So in all of this stuff, and I've alluded to this question before, but I kind of want to bring it fully up front. And not to be an apologist for end-user license agreements in terms of service and all the contractual stuff that we spent the last 3 weeks talking about. Originally, were all those contracts in their embryonic form really a next level way of protecting the magic circle? Because the magic circle was and I have hopefully demonstrated to you that the magic circle was a really prevailing meme metaphor around gaming from the mid-90s onwards, in one form or another. It may not have been called the magic circle until 2003, probably, by gamers, but the notion that this was different, that this was our own, and that the real world had nothing to do with it, certainly was very, very real. Every once in a while, I have the first copy of Wired magazine I bought was in 1993 or 1994, and it's, once a year I try and open it up and sort of go back through it and see what's there. And the psychology around digital and online was very, very different. And so in that context, and it's hard to go back, and I wasn't there, so I can't say I'm sure about this. This is more looking back from a present perspective. It makes sense that contractual rules that were different from the prevailing legal constructs that applied to the real world could actually be seen as a positive by developers. In other words, we want to protect this space, and we need to protect the space to have our own rules, because those rules don't work. That's, it's a pretty counterculture culture at that time. So, and then somewhere in there, and I really believe it was where everything went. When games went online, lawyers got involved, liability issues started happening, and got this kind of massive expansion along very traditional legal lines of what was in end-user license agreement in terms of service. So, point being, it may have originally been an outgrowth of the magic circle idea to have EULAs and TOSs. Now that the magic circle has either shrunk or doesn't exist, maybe that makes the present form of EULAs in terms of service look even more anomalous. So, just to go back, I put in red EULAs in terms of service would insulate from real-world laws. So what real-world laws am I talking about? So I want to take you through this. And I'd like to point out that it is only a coincidence that there are 11 layers of control enumerated here, and that if you add introduction as a 0 and an ethical summary as a 12, you end up with 13 weeks that could be a course that I'm teaching here next September. So just treat that as a pure coincidence. The notion here is to just parse out what are the layers of control on any creation. And they're pretty deep and a lot more profound. So when you look at end user license agreements, even though that you will find them here, you can see if they are about creating a space, what are they creating a space against? Well, a lot of this. And the notion behind here is, imagine you are a creator of a game or anything else. Imagine you're Andy, and you have an idea, and your idea has to actually traverse this gauntlet. And now you sort of start seeing the business that we're in here. There's a dotted line, and before going through the gauntlet, I just want to point out the dotted line. The dotted line is where the magic circle, if you believe in it, is. And there's, even though there are laws and rules, they tend to be ethical ones, not normative ones. And the first 6 really apply in the creation and apply to the creation. And the ones that are above the line tend to be governmental state intervention of one sort or another. So yes, the state adopts what contract law is, but contract law is inter partes. So you start out with extra legal norms. What is extra legal means? Basically, community normative values, community values, and sort of the best example. And it's in your materials. There's in the Copyright X course from Harvard, if you look at it, you'll see an entire session on extra legal norms. And it's well worth watching, and it's hysterically funny because it's about extra legal norms in comedy. So you've heard from Jennifer, and you may know anyways, that jokes are not copyright. So how does the community of comedians deal with comedians who steal each other's jokes? And the answer is there's a customary norm. And that is, if I steal your joke, I've got to pay you $100, $150, $200 is sort of a going rate for jokes. Or you get to smash my face in. Quite literally. That's how, I mean, it's really well worth watching this piece. And the other thing that's revealed in there that I won't reveal here, and I do this to unabashedly make you watch it. It is revealed in there what world-renowned comedian that you will have heard of, that when this world-renowned comedian walks into a comedy club, the other comedians refuse to take the stage because they know he's going to steal their jokes and he's going to be on the Tonight Show with their jokes, and as soon as he tells their joke on a world stage, it becomes his joke. So it's, I do it consciously because that comedian has not sued Harvard Law, so I'm going to assume that, it's probably true. But it's in there, and I want you to watch it. So that's extra legal. That's community impact on your creativity and what the rules of the road are. And it's terribly important to creators because we all live in a context. You live in, you're law students. There are norms to being in law school. You know this more than anybody. And to what you do and how you act and what papers you write and what, and how you deal with other people who are writing similar papers or thinking about similar things. And some of you are kind of setting the norms and others are nervous about them, and some people don't care. And I mean, it's an interesting structure, and that exists in all creative endeavors. The second layer, not terribly legal, is technology. And I tell you, just from a personal standpoint, as I've learned to navigate my way through in the last year around WordPress, I find that technology inadvertently or advertently forces creative choices on you. I know that's obvious, but when you're really making something, it becomes really, really clear. There are lots of things you want to do that you can't do because you don't have the technology to do it. It may or may not exist, and it's fascinating as I've been teaching and starting to work with technology more and more, the actual creative choices that technology forces. Then we get to a layer of copyright and users' rights, which we've explored endlessly in this course. Then a next layer, and I think they're separate layers, I originally had them together, trademark patents and what I'll call the IP business. Gee, if I do that, I could get sued. It exists on both levels, but it's really the IP business thing. I really want to make a Tetris-like game, but Tetris sues everybody in Jennifer's words if you're too close. Do I really want to go there? So that's affecting your creative choice. Then we get to EULA's terms of service and other contracts, and we've spent 3 weeks on that, so I don't have to talk a lot about that, but no question that's going to affect your creative choices. And these are all, now we're getting into legal contexts. So 3, 4, and 2, the reason you might or might not have certain tools might actually be legally related. So you might not know why, as a creator, you can't do this, but it may be that the builder of the tool didn't have the right to include what you needed, or was it somehow limited. So there could even be, there could even be law behind 2, and possibly even, if not law, mythology around law in 1. So kind of law pervades all of these things. And then privacy, defamation, personality law. Privacy kind of jumps the shark because it shows up in 2 places. It also shows up under surveillance under 11. I mean, we're going to talk in 2 weeks about privacy, and there's very distinct meanings of privacy in a inter partes way and a surveillance governmental way. There's two totally different things going on, and they're often conflated and confused and made to sound like the same thing. So this is kind of the tort IP-ish. We've talked about that. Then we get to